Let's move forward with the 14 ways to protect the ones you love. Obviously, have an estate plan and have, as part of an estate plan, your living documents in place. The living documents are what protect you during your lifetime. Now, protecting you during your lifetime also has the effect of protecting the ones you love and your money during your lifetime. One of the biggest risks is having the state involved with your business. So number one on the list of 14 ways to protect your loved ones is to avoid a court-ordered guardianship or conservatorship. Keep the state out of your business. If something happens to you, such that you become incapacitated, and there's no one who's legally empowered to act on your behalf, the state has no choice but to step in and order a guardianship or conservatorship over yourself and over your finances. There has to be somebody who can make decisions for you. And if you can't make them yourself, and if you haven't put into place your living documents, there's no choice. It's required, it's necessary. The state then is basically in charge of your life. And that is much more likely to happen for people who are younger. Why is that? Because they are less likely to have an estate plan. So let's say you are a boomer or you are older and you've gone to a lawyer. They will have prepared for you not just a will, but they will have prepared for you durable powers of attorney. And if your attorney that you met with didn't say, hey, you need not just a will, or what happens at end of life, but you need your durable powers of attorney. If they didn't say that, that's a real red flag to me. Because as an elder law attorney, somebody who helps clients who have disability, families with incapacity, I think the most important document you can have are those documents that keep the court and the state out of your business should there be something that happens so you lose capacity. And those are going to be your durable powers of attorney. So having the durable powers of attorney in place will then make sure, if they're done correctly, that the court will not have jurisdiction over your affairs. You won't be in a guardianship or in a conservatorship. Durable powers of attorney, the best way to protect the ones you love. When I say durable powers of attorney, I am talking about the legal document that you, as the principal, sign while you have the ability to do so, while you have capacity. And what you do is you designate somebody to act on your behalf in case you can't do so. Financial durable powers of attorney and medical and healthcare powers of attorney. Now, it's okay to combine all of that decision-making authority into one document. It can be a combined durable power of attorney that says, I grant authority to my spouse to make financial decisions and medical decisions. That's perfectly fine. As an elder law attorney, I like to see them broken up so that there's a separate financial power of attorney and a separate healthcare power of attorney. The reason for that is, as an elder law attorney, we include our durable powers of attorney are quite robust, quite strong, have a lot of authority, a lot of provisions in them. And to combine them into one document is going to make a very, very long document. So that's one of the reasons I like to have them separate. Another reason is that you might want to designate somebody to be your healthcare decision maker, maybe your son or daughter, and then you want your financial power of attorney to be somebody else. And if you have the same document, it's too awkward. You can't designate separate people. So having the durable powers of attorney in place is the number one thing you can do to protect your loved ones. Because if you don't have that, then the state will become involved in your business. And that's very intrusive, very expensive, and very, very frustrating. Make sure you get good legal advice. Do not use a form. If you're going to use a form document, you're just guessing as to whether or not that is going to be an effective document. And guess what? the document isn't tested until something bad happens, until you do lose capacity. And if that has happened, there's no opportunity to fix it. So I think what I really want to bring home is the point that protecting yourself during your lifetime through really good durable powers of attorney, in case anything happens to you such that you lose the ability to make your own decisions, is probably the greatest gift you can give to your family members, those who are going to be helping you if you do lose capacity. Just like I said, don't use a form. I also don't recommend that you have a power of attorney drafted up by somebody who is not an elder law attorney. And, any estate planning lawyer might disagree with me. They might say, well, these are just forms and documents, and I can prepare an effective, durable power of attorney. I understand what the statute says, in Washington, what needs to be put in the durable power of attorney. But my response to that would be have you ever applied for a government benefit program? Do you know what is required if there needs to be a Medicaid application for long-term care benefits? Do you know the steps that need to be taken to protect assets from state recovery? And if the estate planning lawyer responds, no, of course, I don't do Medicaid, I'm not an elder law attorney, then I would say then you really might not understand what an elder law attorney would include in a general durable power of attorney for finances that you would be unaware of because you don't know the importance of having that authority in those documents. I do recommend in estate planning an elder law attorney and someone who does Medicaid applications.